Vince Farhat, who is a partner in what we call Jeffrey Mangels. They got a couple more people in the title, but we just call it Jeffrey Mangels, Los Angeles office. He's the chair of the firm's white collar defense and investigations group. He was an assistant United States attorney in the major fraud section here in the Central District, I presume, right, Vince?
Yes.
He was the criminal healthcare fraud coordinator for the U.S. Attorney's Office. And as I say, now he is the head of the white collar practice at Jeffrey Mangels. We're starting with a discussion of the plea process, both in federal courts, which Vince will handle. So please go ahead.
Well, thank you. So we thought it would be helpful to start the program by talking about the basic standards in federal and state court, comparing and contrasting those as a backdrop for the discussion of the Flynn case. In the federal system, the Supreme Court has described our federal criminal system as a system of pleas, not a system of trials. The Sentencing Commission has found that 97.6% of federal criminal convictions are obtained through plea bargains. Fewer than 3% of cases go to trial in the federal system. So we really are a system of pleas. What is the standard in federal court? It's governed by Rule 11 of the Federal Rules of Criminal Procedure. Rule 11B in particular sets out the standard for the court to consider and accept a guilty plea. The Rule 11 requires the court to take 4 basic steps in considering a guilty plea. First, the court has to address the defendant personally in open court. That's right there in the rule. It has to be in open court, and the court has to address the defendant personally. Oftentimes, the defendant is also placed under oath. The second thing is the judge has to advise the defendants of the rights that he or she is giving up by pleading guilty. Also, the nature and extent of the charges, has to explain any statutory maximum penalties, any mandatory minimums, has to discuss any appeal waivers that might be included in the plea agreement. The third thing is that the court has to, following its conversation with the defendant in what we call the Rule 11 plea colloquy, has to determine that the plea is voluntary and not the result of force, threats, or promises, other than any promises that might have been made in a plea agreement that was before the court. And lastly, and equally important, the court has to determine that there is a factual basis for the plea. Now, in our district, here in the Central District of California, we have a long tradition of having plea agreements that are very, very long, very detailed, much longer than in some other districts, akin to a phone book, that really are intended to cover every aspect of the Rule 11 colloquy. They're typically signed and filed in advance of the change of plea hearing, and they're really structured to track the Rule 11 colloquy. The basic elements in our district are, first, there's a nature of the offense section, which is a section that describes the elements of the offense or the offenses that the defendant's proposing to plead guilty to. There's a section that discusses penalties and restitution, and it has to include a discussion of statutory maximum penalties, restitution, and the like. There's a factual basis. Now, sometimes this is embedded in the sort of the 4 corners of the document, or sometimes it's an appendix attached to the plea agreement, but the factual basis lays out, in some cases, in some very extensive detail, the facts that the government believes it could prove if the case went beyond, if they took the case to trial and could prove beyond a reasonable doubt. Most importantly, there has to be sufficient facts to cover the elements of the offense. There's typically a discussion of sentencing factors and the advisory sentencing guidelines, and if there are agreements between the government and the defense as to any of those advisory guideline calculations, they're included there. There's typically a section including a waiver of constitutional rights, and that's something that we'll talk about with respect to the Flynn case because there were waivers in that plea agreement. And it really is full disclosure of essentially all the rights the defendant is giving up. And here in this district, it's basically everything, including the right to pursue affirmative defenses, Fourth Amendment claims, Fifth Amendment claims, and the like. Most plea agreements in this district include a waiver of appeal of conviction, limited mutual waivers of appeal of the sentence, and then there's a series of provisions that talk about the consequences. What happens if the defendant seeks to withdraw the guilty plea? What happens if there's a breach of the agreement? And again, these sorts of policies are at issue in the Flynn case. And the answer is all bets are off if there's a breach or if there's a request to withdraw the guilty plea. The plea agreement also explains that the court and the probation office are not parties to the plea agreement. Now, there are very limited circumstances under Rule 11C where there can be a so-called binding plea agreement, but for the most part, plea agreements are not binding on the court, and there's a discussion in the plea agreement that talks about that. There's typically an integration clause that makes it clear that there's no additional agreements in the plea agreement, and a statement that that plea agreement is going to be made part of the guilty plea hearing. Now, just in the last 5, 6, 7 years, there's also been an addition of the plea agreement. When I was in the office, it wasn't included, although it was typically embedded in other provisions. But now, in plea agreements in this district, there's what's called a certification of the defendant. The defendant has to file a certification, sign a certification, and so does his or her attorney. The certification of the defendant is designed to reinforce at least the indicia that the plea is knowing, voluntary, and intelligent. So the things that a defendant is asked to certify is that he or she has had enough time to review the plea agreement, consider it, discuss it with the attorney. That they understand the terms and agree to the terms, that no promises or inducements or representations have been made other than what's in the plea agreement, that they're satisfied with their attorney, and that they're pleading guilty, and these are the words that are typically included, quote, because I am guilty of the charge and wish to take advantage of the promises set forth in this agreement and not for any other reason. So that plea agreement gets filed with the court, and then we have the change of plea hearing. The interesting thing about these hearings is that it's the court that runs this hearing, not the prosecutor, but the court. They run the guilty plea hearing from start to finish. The defendant is typically placed under oath, although that's actually not required under Rule 11. Under Rule 11C2, the terms of the plea agreement are made part of the record. And then what the court will do, and again, the judge's practices will vary, but typically they'll have the assistant U.S. attorney read key sections of the plea agreement into the record, including the factual basis. The court will then question the defendant to confirm his or her understanding of what was read. Do you understand this? Do you agree? Did you do the things that have been alleged? The judge confirms on the record that the defendant understands that the court's not a party to the agreement. The judge confirms on the record that the defendant understands that the court could sentence the defendant up to the statutory maximum. And then the judge goes over that certification that I mentioned, typically having it read into the record and making sure that that's their signature. At the end of this, the court has to make findings, the findings required under Rule 11. And it's interesting, and representing clients in guilty pleas, you'll sometimes walk out of there and the client will react and say, I thought that the judge was trying to talk me out of it, talk me out of pleading guilty, because some of these guilty plea colloquies are very, very thorough. Some of the judges in our district will spend over an hour just on a single count plea agreement. One thing, of course, that's at issue in the Flynn case is what's the standard for withdrawing a guilty plea before sentencing? And again, the general standard in federal court is set forth in Rule 11. And that's a defendant may withdraw a plea of guilty before sentencing if the defendant, and these are the kind of the magic words, a defendant can show a fair and just reason for requesting the withdrawal. Now, that's the language. Now, what have courts, at least in the Ninth Circuit, said are fair and just reasons? Well, for example, an inadequate Rule 11 plea colloquy, newly discovered evidence, intervening circumstances, erroneous or inadequate legal advice, conflicts of counsel, things like that. And again, at least the rule is such that it's a fairly liberal standard. How is it reviewed? Well, a district court has the sole discretion to determine whether to accept a withdrawal of guilty plea. Here in the Ninth Circuit, that's reviewed for abuse of discretion. Factual findings are reviewed for clear error. Now, here in the Flynn case, in the brief that was filed today with the district court, for the first time, we've seen a sort of a clear statement of General Flynn's position regarding his guilty plea. He contends that there were flagrant Rule 11 violations. He contends that the first judge that took the plea had alleged conflicts of interest. They make an allegation that Judge Sullivan did not ask whether there were any additional promises or threats that were made to Flynn. He alleges in his filing today that the court accepted his guilty plea, notwithstanding undisclosed conflicts of interest by his counsel, and he makes an argument that there was significant Brady issues. So we'll discuss that later on in the program, but that's how they're trying to connect the Rule 11 standard with their filing. One question that comes up, and it is an issue in this case, is whether material impeachment evidence can be waived in taking a guilty plea. And the answer is, at least constitutionally, yes. In the case of United States versus Ruiz in 2002, the U.S. Supreme Court, in a 9-0 opinion that was delivered by Justice Breyer, held that the Constitution doesn't require the government to disclose material impeachment evidence prior to entering the plea agreement with a criminal defendant. There were a number of reasons enunciated by the court, including Justice Breyer's comment that requiring disclosure of the evidence would improperly force the government to engage in substantial trial preparation before plea bargaining. Now, the ruling of that holding in Ruiz is actually limited to material impeachment evidence, but the Department of Justice has taken a broad view of Ruiz. In the Justice Manual, which is formerly called the U.S. Attorney's Manual, the government broadly construes Ruiz as barring mandatory disclosure of just about all exculpatory evidence. If you look at section 9-5001B, the government states, the Department of Justice states, that neither the Constitution nor this policy, meaning the Justice Manual, creates a general discovery right for trial preparation or plea negotiations. And that's the government's position. In the Flynn case, there was a waiver. The plea agreement includes a provision that states, quote, your client agrees to waive all rights, whether asserted directly or by a representative, to request or receive from any department or agency of the U.S. any records pertaining to the investigation or prosecution of the case, including without limitation FOIA records and things like that, for the entire duration of the special counsel's investigation. So the plea agreement here in the Flynn case does include a waiver. It doesn't necessarily mention Brady by name, but it clearly it appears to apply to requests for exculpatory records. So that's the basic standard in federal court. Because it's a very thorough process, it's very difficult to unwind guilty pleas, and we'll see what Judge Sullivan does in the Flynn case.